Hello and welcome to IGPP Expert Talks. I'm Hina Goswami, editorial consultant with IGPP, Institute for Governance, Policies and Politics, New Delhi. At IGPP Expert Talks, today we discuss a topic that has become a bone of contention as the AI generated content takes over the traditional content we usually consume through books, movies, and social media. And to discuss the same, today we are joined by Ms. Meghna Bal. Ms. Meghna is the director of SCR Center, a lawyer with deep experience in media and emerging technology. She has previously worked on legal and policy strategy at the Walt Disney Company. Before Disney, she set up and led the India office for Consensus, the world's largest blockchain technology company. She has also co-authored The Dazzle of the Digital, a book that delves into digital technologies, linkages with progress and modernity in India. Welcome to IGPP Expert Talks, Meghna.
Thank you for having me.
Can you briefly explain the current issues regarding AI-generated works and copyright IP laws across the world, also highlighting the recent issue in India related to OpenAI?
Essentially, what publishers of news publications like New York Times, as well as authors, are saying is that AI systems, generative AI systems like ChatGPT, are trained on their works, and this usage of their works is unauthorized. And so they're saying, and for instance, in the New York Times complaint, they've also shown as evidence, that there have been like broad kind of not replications but reproductions of New York Times articles and verbatim. Now that litigation was some time ago, and since then, of course, OpenAI has started getting into licensing deals with different companies in the US. The ANI complaint is largely the same, except there's an additional issue of defamation that ANI has brought forth. It's basically also filed a defamation suit against OpenAI because ChatGPT, I think, said something to the effect of ANI is kind of purveying fake news. So that is the sole kind of difference. But largely it's the same. Basically, there's publishers are saying that this is unauthorized use of our works. And I mean, there's many kinds of arguments that AI companies take. OpenAI in the New York Times case, for instance, use the Google Books case, saying that it's transformative and non-expressive use. Whereas over here, they've taken different lines. They've said, they've raised questions of jurisdiction. They've also said not only geographically, but also because there's a defamation suit that has been brought in as well. Um, and and they've said that the data is based in America, so there's no jurisdiction here, et cetera, et cetera. So, I mean, the way that they seem to be fighting this case over here seems to be somewhat different from how they've kind of fought litigations abroad, and that is also, I think, maybe has to do with the nature of copyright law here versus in the US. But we can get to that later.
So traditionally, we know humans to be creative and they are considered capable of producing creative works that receive legal protection. How does the technology of AI challenge this principle?
So, I mean, essentially, a good way to think about it is the difference between AI and traditional software. Software is programmed to do a task, and AI is taught to learn how to do a task. So essentially, it's kind of supplementing or supplanting a human expression like generative AI. That's what it does. It creates. So the I mean, like, let's say in the case of patents, academics and practitioners argue that AI systems should not be granted inventorship because doing so would conflict with the purpose and objectives of the patent system. Basically, the patents are granted um, to patent holders to give them a monopoly over the exploitation of their um, inventions in return for publicly disclosing their technology, which then creates the basis for further innovation. But in India, this is kind of resolved by Section 2D because it says very clearly that the author of of a computer generated work is the person who enables, is a natural person, or I mean even the legal person who enables the creation of that work through the computer. So it's very clear, the position here. It's not really a question over here. No problem.
So, if an AI model reproduces copyrighted content in verbatim or in a substantially similar manner, should liability then fall on the AI company which is producing or the user who provides the prompt?
Yeah, output, it's kind of a separate issue from what is actually being, uh, somewhat separate issue from what is being discussed in courts, though it's a part of it. I mean, but essentially, if it reproduces, then it depends on the nature of, I mean, yeah, it's an open question, I would say. It depends on the nature of the license agreement, or the end user license agreement, like what is the company deciding. So, for instance, DeepSeek, which is that new Chinese AI system that's kind of all the rage right now, it's very strict about IP licensing. It says that all works that you produce using DeepSeek technology belongs to DeepSeek. Um, and I'd have to look at the licenses of other other services to see whether there's a distinction. But this is one thing that, like, reports have highlighted about DeepSeek. And I mean, the basic technical challenge is like, how are you going to monitor this? For instance, when you're talking about royalties or you're talking about infringement, unless you yourself are going on on that chatbot and like constantly getting it to churn out things, or you see something that someone else has churned out and they've reported it, I think it's like almost impossible to be monitoring this in real time. And it's different from like finding infringing copies um, on social media or any other media, right? Because they're whatever, it's like you find the signature and you find copies and you can do a little word search and you find it. And typically that's a reproduction. But this may not necessarily be a reproduction. Um, it may be a small excerpt. You don't know, for instance, because let's talk about text, because there are so many sources of data that have fed into this. You don't know to what extent, even if it is a reproduction, you don't know to what extent it's come from your data as opposed to other data, where there may have been similar patterns when it comes to text, right? So I think it is quite a complicated scenario. Um, and it is an unclear scenario that the courts can clear up, um, or the law can courts would clear it up sooner, as to like who the liability would fall on. Definitely, if there's reproduction, like verbatim reproduction, there would be a liability, provided that that work is not in the public domain, and like the kind of fair dealing exceptions don't apply. Um, uh, there would be, but uh, it just depends on the extent of the work reproduced and all those other considerations. And yeah, I mean, I don't know who it would fall on. More likely to fall on the AI company, because I just can't see like people using it, reusing it. I don't know. That I think is an open question. Just in terms of like, if there's a reproduction of someone's voice or a reproduction of someone's likeness, that there's clearly a liability. You cannot do that. So whoever's kind of using it, and we've seen it with a couple of film stars as well as some singers, you you're not allowed to do that. It's both a privacy right as well as a personality right. It's not allowed. It is like clear cut infringement. I think with text it's slightly murkier or uncertain.
We know that one of the reasons why Gen AI has suddenly become all the rage is because there's a lot of data that is available in the public domain, which was used to train AI models. So, to what extent does training AI on publicly available content fall under fair use, and where does it cross into copyright infringement? And how long is the fair use doctrine justified when applied to AI generated content sourced from unlicensed training data?
So it depends, right? I mean, this is kind of the open question. Many companies contend that essentially there is no human seeing this data, and what these data sets don't comprise of, these entire works. They are essentially metadata about, so it's data about the data. And in that case, it's purely factual and it would not be copyrightable. But others contend that, for instance, people who are fine tuning these data sets, they are going through works to see what is useful, what is not, or maybe going through works to see what is useful, what is not. And so that, like, parsing means that, there is some kind of reproduction. In India, we have fair dealing, and in the US, they have fair use. And fair dealing is much narrower than fair use, because fair dealing is very clear that there are only three exceptions: personal use, research, and that doesn't include commercial research, um, and news and reporting. Um, and of course, we have, like, in a 2012 judgment, imported the kind of four conditions that you need to meet fair use into our law as well. But it is within that narrower framing of fair dealing. So I think that's something that kind of gets lost and forgotten. And also, I mean, the funny thing is that even the Delhi High Court has used the term fair use, even though we have in India, it's fair dealing and it's much, much narrower.
Courts have also ruled in some cases, and the case of Google Books that you mentioned, that digitizing and analyzing copyrighted works for search and indexing can be transformative. Could similar reasoning also apply to AI training? And Google defended itself by arguing that transformative use justified scraping text from books to create its search engine. Does this argument also hold for AI models today?
I think certainly it's much stronger in the case of AI models because, I mean, it is wholly transformative. You can't tell me that, like, ChatGPT is the same as a news publication. And it typically is non-expressive, right? Um, because the thing is, when you put in a prompt, you don't know what it's going to spit out. And what companies are doing is that they're in putting they're increasingly putting more and more guardrails to ensure that, you know, their generative AI systems don't produce works that are basically copyrighted. So for instance, if you tell ChatGPT, or even, like, the likeness of a famous person, because that comes under personality, right? So if you tell ChatGPT to generate the image of a certain person, they don't they or of a celebrity, they don't let you it doesn't let you do it. um Similarly, for, different works that may be copyrighted, it will not let you do it, but it's not always predictable. And there are ways, I think, that you can kind of jailbreak it into breaking the rules, which basically means that you can kind of trick it into breaking the rules that developers have set for it. But that's an iterative process. But yeah, I think there's a very strong argument for very strong argument for transformative use. There's another argument that, the data set that has been created to train AI systems, that in itself holds a separate uh, copyright. And I think there's a strong case to be made for that. I don't think, of course, right now, I think OpenAI is just trying to get the case thrown out. Um, but I think there's a very strong case to be made for that, because that modicum of creativity threshold that we have in India is quite low, you know. And so, given the amount of work it takes to fine tune, I mean, like, to create data sets for specific use cases, even if it is for foundational models that are ingesting tons of data, I think there's a strong case to be made that this data set is separate from the work, because, whatever, it's metadata. We've used all these techniques to filter out, toxic things, or things that we consider toxic, and to try and remove bias. And we've like basically like cleaned the data. Um, so I think there's a strong case to be made that there's a separate copyright within the data set that has been created for a particular purpose, for training a particular model.
Stability AI discussed an opt-out method for excluding copyrighted works from from training datasets. So, should AI companies consider such approaches, like an opt-in approach, maybe? And what would be the challenges associated with training AI models on such methods?
It's come up in the OpenAI case as well, where OpenAI said that it's basically opted out ANI from, I think, October 2024. So I think most companies are using this opt-out approach. I mean, the basic challenge is that it's still very much an open legal question as to whether it qualifies as unauthorized use and copyright infringement. And so until that is kind of decided, um, it makes limited sense for companies to offer an opt-in approach. And also, I mean, what is the incentive for people to kind of opt in? So I don't know if an opt-in approach works. Of course, that's what publishers are pushing for, but I don't know if an opt-in approach, I mean, an opt-in approach basically means some kind of licensing deal, right? Um, or someone who just whatever, I mean, maybe something is being developed for research, and so people opt in, or government, for instance, could opt in and say that we have like troves of data, we're happy to make it available to you, to for development of models, or development of AI models in the country, etc., something like that. And over there also, I mean, it's different because it's factual data, it's not really copyrighted. But I think an opt-in approach in the context of copyright holders, I think it means licensing, or for a very narrow purpose, which is non-commercial. Um, but I don't know, I don't see these products as competitive with um, creative industries. I see them as very much complementary. I mean, there is a lot of hyperbole about their abilities, and of course, a lot of people, and particularly even New York Times made this argument against OpenAI that basically, oh, OpenAI is also eating our lunch. But I don't think that's the case. It is extremely complementary. It cuts down the time that it would take for a lot of the mm, kind of nominal tasks that you have to do, either in a publishing room. And of course, like um, some publishers, I don't, and it's questionable that they're doing this, but some news publishers in India are like doing away with entire newsrooms and like just using these systems, and using much fewer people to generate stories. That's really risky, in my opinion, because they do have a tendency to hallucinate, and you can't stop hallucination. But yeah, I mean, more and more it's coming out that this technology is complementary. So I don't understand this impetus to just, kind of try to shut it down or make data more expensive.
Considering that technologies such as AI and before that digital technologies do not really have, do not adhere to like national boundaries. Do we need a global framework for AI and copyright to ensure consistency across jurisdictions? And how should disputes be handled when companies like OpenAI, which have no physical presence in certain regions, when they are subjected to the laws of the land?
Yeah, I think I don't know. I think the jury's out on whether OpenAI has no presence here. Um, it's something that used to be presented as an argument by US technology companies in the past. And I think it's a really kind of, I don't know, I think it's an unhelpful argument, because all it does is it makes the case for things like data localization, and, uh, forcing registration. I don't know. I'm not sure I agree with that argument. But on the need for a global framework, no, I don't think it's needed because right now, what you're going to see is you're going to see jurisdictions compete for investment and for companies to come to their I mean, to kind of set up or, register over there. So, for instance, Japan, I think, has done a really smart thing. They've been very clear about, I mean, they've brought in a text and data mining exception to their copyright law, and it's a very broad exception, and it allows for both commercial and non-commercial research. It accommodates both. Um, and I think copyright holders were against it, but I think the Japanese government has just taken a call that, this is an area that's going to grow and we want investment, and this is the best way to do it. So yeah, I think that it's, and I think it's impossible to have like, complete rationalization across countries unless there's a treaty. Um, I don't see all countries signing on to it, agreeing to it. Um, Particularly because there are, over here it's very different, and it's quite an interesting. It's very different from previous treaties where, um, there's like a north-south divide, or there are some who are like very copyright or right of copyright, very copyright strong, and others who are not. Because here essentially, um, I don't know, you have two sets of innovators pitted against each other. So I'm not sure whether a treaty is feasible. What I do think is that there is going to be competition amidst jurisdictions for attracting investment and like, AI companies to set up within their jurisdiction. And I think that Japan is like far ahead in that.
Some jurisdictions like EU also have transparency requirements and they are pushing for more disclosure in AI training data. Would that affect AI development, and what challenges do AI firms face in complying with such regulation? Are they justified, I mean, in the first place?
I mean, essentially, I think copyright holders have pushed for transparency because they want to see what's in the training data sets. But not copyright firms, sorry, AI firms are against it because it's essentially a trade secret, right? What I do with my data set, how I arrange it, and all of that feeds into what my product does. And there may be something that I'm doing that others aren't, which gives me an edge, particularly with my data set. And why should I be forced to disclose that? And because of EU's AI rules, essentially, you're seeing large technology companies are just not releasing their AI products there because there's so much uncertainty that the EU AI Act has created around this. And I think there's also some questions about whether the Digital Markets Act applies to AI products and things like that. So, uh, or whether it's going to be extended to, I think. Um, but basically, the point is that, the EU may be a first mover on this, but I think it's moved too soon because this is a rapidly evolving field. It's still very nascent. And when you do things like this, particularly in any field of technology, but particularly this one because it's moving so fast, you know, uh, you run the risk of one, like bringing out regulation that's already obsolete by the time it's come out, which to some extent the EUAI Act is, or bringing out something that's not really in touch with how things are playing out on the ground, which sounds kind of similar to the previous point, but it's not. Um, and essentially, what you're going to do is you're just going to drive companies away, which I think the EU was kind of betting on because they have this kind of narrow view of digital technology as only being big tech or largely being dominated by big tech companies. But that's really not the case. And I think, um, kind of disruptions like the one we're seeing from DeepSeek speaks to that. And I think it's like a fundamental flaw in the way that the EU thinks about digital technology regulation, that they only tend to focus on large companies and make their laws based on them and certain risks as well. Um, Certain kind of precautionary risks that are not necessarily in touch with reality. And I mean, I could go on and on about the EUA Act, but I won't. But I'll just stick to that, that basically it's a trade secret issue. I don't think transparency requirements are particularly helpful because who is going to be evaluating, this? And I mean, um, uh, I think we also need to think about the caliber, not the caliber, but the qualifications of people evaluating this. And then, of course, yeah, I mean, like, I think trade secrets are the paramount kind of consideration there, is that why should a company disclose something that is so kind of foundational to its product, you know?
Makes sense. The Indian Parliamentary Standing Committee, in its 161st report, suggested creating a separate category of intellectual property rights for AI generated innovations. Would that approach help address the challenges of AI generated content authorship?
I mean, it doesn't come up in India because we have Section 2D. I mean, under Section 2D, it just doesn't come up over here. It's quite surprising actually that they said this, but yeah, I don't think it comes up. Might come up in patents. It doesn't come in copyright. Sorry, it might come up in patents, and that's a separate issue. We've actually written about it. Um, uh, and I haven't really thought about it much in the context of trademarks or design. But yeah, it might come up in patents. But I mean, yeah, I mean, you can, I guess, there are some projects that are, specifically like there's this thing called Davos, which is a project that is being carried out by researchers abroad, where basically they filed a patent application for AI generated inventions. And different countries have different positions on this. I don't think it's problematic, but I don't think, and I understand where it comes from. Um, because there are many cases where, and basically the system has devised a novel method, or it's completely from the system. It's not, there's like the human being has not played any role in it. And so those um, inventions kind of then exist in a land of, I mean, a complete gray area when it comes to who has invented them. The simplest way, of course, would be that whoever owns the company or whoever's kind of trained that AI system or whoever's working with it to generate it gets the invention or gets the credit for it. But I don't know, it's still, I think, an open debate.
Is there a possibility of granting legal personhood to AI? And I mean, would that solve problems related to copyright? Or otherwise, what would be the challenges that would arise when assigning authorship to AI?
I don't know what problem it solves really, ascribing personhood to AI systems. Um, because how are you going to hold it liable? You know, it doesn't really solve for anything. And we're very far away, if not I mean, impossibly away from artificial general intelligence. So I don't see what the purpose is in granting these systems personhood.
What, according to you, are some of the possible ways to regulate AI generated content while balancing innovation and copyright protection? And how can AI systems be designed to avoid potential copyright violations while still providing informative and creative responses?
I mean, like I said, TDM, text and data mining exception, like the one Japan has introduced, that's kind of the clearest way. That basically it opens the door for scraping. Um, uh, I don't know if it would pass here, if there's any interest in introducing it here, but I think that is something to consider. That would be the best way to balance it. Because has tried really hard to ensure, because of course it's got a very kind of thriving and important copyright industry as well, right? Both in gaming and in movie production and even in book publishing. And a lot of it's really like big technology companies are broadcasters and publishers, etc. So um, I think that there is a way to balance it, and that is, introducing like a well-worded TDM exception. Whether there is appetite to do that, I'm not sure.
Thank you so much, Meghna. That was all the questions that we had. Thank you for sparing time for this podcast.
Thanks so much. Thanks so much for having me.